Good morning. This is Citrus County Planning and Development Commission hearing for July the 17th, 2025. If you'd like to join us at this time, I invite you to please stand for the invocation and remain standing for the Pledge of Allegiance.
Dear Lord, please give us the grace to be understanding, patient, and tolerant. With these attributes, we can conduct our work in a manner which will be pleasing to Thee, our county, and its residents. In the Lord's name, amen.
Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, thank you. For the courtesy of the applicants, the board, and those around you, at this time, if you can place your cellular devices on mute, and may we get the roll call, please.
The following Planning and Development Commission members are present. Chair Richard Barmez, David Bramblett, first vice chair, Robert Shera, second vice chair, Stuart Bozeman, Jeanette Collins, Michael Facemeyer, and Kurt Stone.
Thank you. If any person decides to appeal any decisions made by the commission with respect to any matter considered at this hearing, he or she will need a record of the proceedings, and for such purpose, he or she may need to ensure that the verbatim record of the proceedings is made, which records includes testimony and evidence upon which the appeal is to be based. During the public input portions of the meeting, individuals are given 3 minutes, and representatives of an organization is given 5 minutes. When anyone wishing to speak comes to the podium, please complete the yellow form to hand to the recording secretary, and please print your name, address, and the number of the application for which you're speaking on the form. The yellow forms can be found at the podium by the door. If representing an organization, a letter of authorization must accompany the speaker. The comments will be limited to the topics being heard, so please state your name, spell your last name, and give your address for the tape record. Now, at this time, I'm going to open up the podium for the public. This is an opportunity for you to come forward to address the commission on any issue that you may wish, but it's not about any application that's being heard today. Anyone? Seeing none, we'll move right on and close the public portion of the meeting down. We have no minutes to approve. Do we have any staff announcements?
None at this time, thank you.
Thank you. If we can get the ex parte communications from Madam Attorney. Oh, good morning.
Good morning. With regard to the application you're about to hear, have you had any ex parte communications? And we'll start at the end.
No.
None.
Site visits.
None.
None.
Site visit? None.
Thank you, Mr. Chair.
All right, great. All right, it's time for application B-2025-00001 for Aluminum Structures LLC for Walter and Annette McFall. If the applicants are present, can work their way to the podium as we get the staff introduction, please.
Yes, sir. Good morning. This request is for a variance for the placement of a proposed accessory structure having less than the required 50-foot minimum building setback from the center line of a local right-of-way. This is an aerial view of the subject property. The subject property includes lots 114 through 120. This is looking northeast on North Palmer Way. This is looking southwest on North Palmer Way. This is looking southeast on East Hilltop Loop towards North Carl G. Rose Highway. This is looking northwest on East Hilltop Loop. This is the site plan submitted by the applicant. Thank you.
Thank you. Good morning, sir.
Good morning.
It's all yours.
You
can state your name. State your name.
My name is Shane Cotta. I'm the one that filed a variance on behalf of McFall. The garage that we're trying to submit is equal with the house. I mean, it's not pushing it any farther to the road than the house is. Neighboring houses are, don't meet that 50-foot setback. I mean, I don't see where it'd be a problem in the future. The roads are dead end. It's not like it's going to expand anytime soon. don't know what else to put.
That's it? That's all you got?
Yes, sir.
All right. Yeah. Does the staff have any questions for the applicant?
Yeah, so the staff report had a lot of concerns about unpermitted structures on the site, and those would have to come off if this is approved. You understand that?
I understand.
Or be permitted? Okay, and the Connex can't at all stay, so that would have to come off. That's something you understand too if this is approved?
You're right.
Right, okay. Thank you. Nothing else.
All right, does the board have any questions for the applicant?
Mr. Chair,
Commissioner Shara.
good morning.
Good morning.
You made a comment that if approved, the garage would not extend any further into the setback than the existing house.
Correct.
So the outer edge along Hilltop would be the same as the existing house.
Yes, sir.
An existing house encroaches 6 feet within the setback at this point.
Correct. According to the site plan up there, yes.
And the staff question of you representing the McFalls is that the non-conforming uses that are there now, the unpermitted uses, would be corrected.
I haven't talked to him, but that will be what I will express to him when I do talk to him on the phone today. I mean, he's got to clear it up. You got to have permits for things that you build.
And, okay, that's great, thanks.
Any other questions? I have a few, but I'm not sure if you can be able to answer them because you're not the applicant. But I'll throw one out there at you. How long has the applicant owned this property?
That I am not aware of.
And is his business still in business at this location, the TNT sewer?
I believe, I've only heard this information secondhand, but I believe it's just where he's storing stuff. That I have no idea.
All right.
None.
Well, I won't bore you with any other questions on that
All right.
then.
Mr. Chair, can I get the representative to spell his last name, please?
Hey, can I get you to spell your last name?
Cada, C-A-D-A.
Thank you.
You're welcome.
All right, any other questions from the board? Commissioner Facemeyer.
And here again, you may not have the answer to this question, but if we were to approve this application today, have you had any conversation with the owner to see if the owner is willing to fix all these 10 issues that are, in my opinion, they're major issues that over a period of time have probably demonstrated, a lack of willingness to do what the county requires?
I mean, it's actually more like 8 because the concrete slab has nothing built on it, which doesn't require a permit. There's a wooden detached patio, per se, in the back. Again, it's detached. It's, as far as my knowledge goes, it doesn't need a permit. But there is a few. The pole barn, the things on the sides, those do need a permit.
Some of those are not insignificant.
Right. I mean, they're eligible for after-the-fact permits too. So, I mean, that's something I would help Mr. McFall with to get that moving.
But it's not out of the question that some of these issues are not only unpermitted, they're non-conforming. So it may not just be as easy as walking down the hall, fill out an application, and get that.
Correct.
And
I honestly haven't really looked at it to see if any of them are sitting in easements or anything like that. But, I mean, it's something that I can look into and discuss with Mr. McFall.
Yeah, and I know you don't have the answers to all those questions,
No,
but you're the only one here, so.
Correct.
Thank you, Commissioner Facemeyer. Any other questions for the applicant? All right, thank you, sir. If we get the staff to come forward and make their presentation, please.
Good morning.
Good morning.
Jen Perkins, Senior Planner. This variance application is a request to place an accessory structure that would have less than the required 50-foot setback from the center line of a local right-of-way. The owner is using 7 lots as one building site, and the 7 lots total approximately 1.21 acres. The white arrow is pointing at an existing screened room that does not meet the required front setbacks. It is located 44 feet from the center line of the East Hilltop Loop right-of-way, which means it's encroaching 6 feet into the required front setback. The owner is proposing to replace that screened room with a detached garage that is wider and also maintain that 6-foot encroachment into the required setback. This is a side view of the screened room to the left of the tree, and that's looking, I think from Palmer. I apologize. And this is a view of the permitted detached garage that is 1,840 square feet that has an office and a bathroom. This is the third gated entrance to the property that has the name of a business, TNT Sewer, incorporated into the gate. 2 pieces of heavy equipment were observed on site. And to answer the question about whether it is still active, I pulled Sunbiz records, and it is still in business. To the right is an unpermitted pole barn that is flanked by 2 unpermitted carports. To the left is an unpermitted shed. In the rear there, you can see some corrugated metal, and that is the shipping container. At time of the site visit, a construction dumpster was located on the property, and you can see one of the pieces of heavy equipment in that picture. So as you'll see on the next slide, or you'll see the site plan on the next slide, but I included this because the dimensions on the site plan do not line up with what is shown here. This is a view of the unpermitted deck and pad, and this is a view from the property appraiser's pictometry. This is a site plan that was submitted by the applicant where staff has indicated the permitted and unpermitted structures that are on the site. 8 of the 11 accessory structures are unpermitted, and shipping containers are not allowed on residential properties. At the top, again, at the top of the site plan, you can see the screened room that is 12 feet by 20 feet that is proposed to be replaced by a detached garage that is 18 feet by 22 feet. Because that garage is wider, it would result in more structure encroaching into that required front setback. Yes, the 6-foot encroachment would be the same, but because the building square footage is more, it result in more square footage encroaching into the front setback, which is expanding a nonconformity. The proposed detached garage could be located elsewhere on one of those 7 lots to meet LDC setback standards and to eliminate a nonconformity. Thank you. One more thing to answer the setback questions. I do not believe that any of the other structures are located within the setback requirements other than the screened room.
Thank you. Does the applicant have any questions for staff?
And
Applicant stated no.
I'm sorry, and Jen, just to clarify, the 3 driveways, engineering had noted they can't have all 3 and they'd have to remove 1, correct?
Correct.
Thank you.
All right, does the board have any questions for staff?
Yes, I do. So you're saying that the structure that's going to be removed is already encroaching 6 feet
That is correct.
into the requirement.
That is correct.
But it's not going to encroach any further, but by virtue of the fact it's going to be more square footage, that increases the encroachment total square footage? Is that,
Correct,
Okay.
which is increasing a nonconformity.
okay, so we're already out of compliance, and we're going to enlarge the out of compliance just by virtue of the square footage, not further encroachment?
Absolutely, you are
Okay.
correct.
Okay.
Sure.
Commissioner Shara.
So a question on the number of lots. You said there's 7 different lots. They're separately deeded to the same owner, or are they actually considered a single lot? And the reason I asked the question, just to give you a second to ponder it, the reason I asked the question is, are we talking only about lot 114 in terms of the addition of the garage and whether or not it's in compliance and it extends into the setback area? But the discussion seems to have broadened into uses on the remaining 6 lots. So can you explain where we stand from a lot perspective?
Correct. So there are 7 legal lots of record that you see up there that are outlined in the blue. But the owner is using all 7 as one building site. So the entire 7 lots are being considered with this application when it's being evaluated.
Okay. So what is the normal practice if you have non-conforming or unpermitted uses when an applicant would come forward with a, request for a building permit? Is there a quid pro quo that the existing non-conforming or unpermitted uses must be resolved prior to considering the new permit?
It can stay, but it cannot be improved, and that means any renovations that aren't considered, what's the word, Joanna, by a building official, that would be a safety issue. Other than that, they cannot do anything, and it would not, if they ever got rid of it, it would not be able to be replaced, because it would be eliminating a nonconformity, and that's what we want, what the
Okay.
county wants.
And we consider then, again, I'm repeating, but just, it's not sticking in my brain, all 7 lots are considered a single lot because they're owned by the same person or the same entity?
So there's just a technicality in semantics. It's being considered one home site, even though there are 7 legal lots of record, because there are accessory structures, et cetera, that expand across all 7 lots that he owns.
I see.
And so-
Did that clear it up?
Yeah,
or-
so just to clarify, those unpermitted structures, if they ask for something new, we're not gonna say, oh, you keep all the rest and you can have this new. They're gonna, permitting's gonna stop and say, oh, you got this, and this first, then we can talk about a new structure. So they do have a problem, it can't stay forever. On the prior permit, they did tie them together, that's the survey that you see here where it says file copy on it. That's an old permit, so they did tie it together. It expands, one of the structures expands on the very farthest lot, so you can see that they do have structures on every single lot. That's why it was looked at as one development site. But they do have some issues on permitting anything out here because they have that extra driveway and they have all these unpermitted structures. So they do have a lot to resolve regardless of your actions and to be able to get a permit.
Can I just restate that? I'm sorry.
Yeah,
Denise,
go ahead.
Well, and also, you can't have accessory uses without primary uses. So if they weren't all considered together, all of that other stuff would have to go away because there's only one primary use. And I think the primary use actually straddles 2 of the lots. So we have no way of considering it individual lots because of the uses that are being made.
Okay, and the
Otherwise,
primary-
all that would have to be gone.
I see. And the primary use is the residence?
Yes.
Okay.
Right. Yes.
Just for clarification for my benefit, if we should approve this today, before a permit could be issued as a condition of that, when you were talking about the permitting process, all these non-conforming or unpermitted uses would have to be corrected before a permit could be issued?
Right, that's something that site review would look at and say, you've got this, and this, and sometimes they'll tell us they're gonna be removed, and that's perfectly fine. The Connex absolutely has to be, and the third driveway have to be. Those would have to be shown on the site plan as removed. The other ones they're gonna have to pull permits for to get something new on there. But again,
Otherwise, they couldn't proceed.
correct.
Okay, thank you.
All right, any other questions for staff? Commissioner Stone.
What's the policy with renting a commercial property, commercial business in a residential area?
Yeah.
What's the county's policy?
You can operate a home business out of a residence, but it has to maintain the appearance of a residence, and not be retail where people are coming and going.
Right, the actual language is no visible evidence of the business so the fact that she could see a sign and some heavy equipment, there's visible evidence, so that wouldn't comply right now with the home occupation requirements. If you have an indoor accounting office and you do it all online, perfect example of a home occupation. But if you put a big store out there with a sign, not at all.
And a backhoe in the front
A
end?
backhoe is, some people have them, but the sign and the equipment is concerning.
It's not a John Deere lawn tractor.
It doesn't sound like it, no.
All right. Thank you.
Thank you, Commissioner Stone. Any other questions for staff?
Follow-up. So as a follow-up, since the applicant himself isn't here to make any representation as to his intentions, the fact that they have these other uses, does that come into, and I'm looking to Madam Attorney, does that come into play for an evaluation of the application for the garage?
I'm trying to see who the applicant is, because I believe that this gentleman is the applicant. He's just not the owner.
Correct.
So
I see.
so the applicant is here.
Okay, good point. Thank
The
you.
owner's not, but he
owner-
speaks on behalf of the owner since he's the applicant.
And he can't, and he said he can't speak on behalf of the owner because he
Well, he
doesn't.
may think he can't speak, but by filing this application, he is speaking on behalf of the owner.
I see. I understand. Got it. Thank you.
All right, any other questions? All right. Thank you. The public portion of the meeting will now be open. If there's anyone present who would like to speak on this application, please come forward to the podium. As a reminder, individuals are given 3 minutes and organizations are given 5 minutes. When speaking on this application, please address the board. And if you have any documentation that you want to be entered into the record, please provide a copy to the recording secretary. Seeing anybody out there? So we have no, we'll close the public portion down since nobody's here. There's no opposition, so we'll bring the discussion back to the board for comments. Commissioner Facemeyer.
Mr. Chairman, I will not be supporting this application. Decisions have consequences. The owner of this property has made many decisions over an extended period of time to disregard county zoning policies and other policies, including operating a business, an unapproved business. I have little confidence that he would correct, even if we approved this today, I have little confidence that he would do the right thing and remediate all these unpermitted items. So just to start it off on the no.
Thank you, Commissioner Facemeyer. Anyone else?
Mr. Chair,
Commissioner Collins.
yeah, I'm unable to support this finding that this is not a minimal variance. The site can be developed to meet the intent of the Land Development Code. Now, the garage is not necessary to make reasonable use of the property, and it will exceed the degree of nonconformity, so I'm unable to support this.
Thank you. Anyone else? Commissioner Scherer.
Mr. Chair. The way I would describe this application, there's a lot going on here. And in fact, if it was singularly looking at lot 114 with the potential of meeting the existing building line, and building a garage, and even potentially expanding a non-conforming use, that would be one set of items. But it goes way beyond that. Since these are considered, all 7 lots are considered as a single from this particular entity. And in fact, they could build this garage and be in conformance by relocating it at another location. Understanding staff's comments that before they could ever get a building permit, they would have to clear up these existing issues. This seems to be something that I can't support, so I won't support it.
Thank you, Commissioner Scherer. Commissioner Bramlett.
Yes, sir. Just to echo what the rest of the commission members said, I wouldn't be in support of it. I wouldn't be in support of this application if the unpermitted structures weren't there. You know, a lot of things were permitted prior to. We have a lot of non-conforming uses here, and like staff said, we trying to clear these non-conforming uses up. I would just say to the applicant that if I heard you say that this was your first time coming in and presenting an application like this, if I would just a little word of caution, if they have 8 to 10 unpermitted structures on their property, you probably need to tell them that they should get that stuff cleared up before they come in here. They basically just told on themselves, not that we can do anything on this board, but should any of their neighbors be watching that are a little unsatisfied with what they've been doing there on that property, now they have an opportunity to file a complaint. So I'm not in favor of this application, and I wouldn't be in favor of it without the unpermitted structures.
Thank you, Commissioner Bramlett. And I would echo everything that I've heard. Being a general contractor, one thing I hate most in life of being a general contractor is contractors who build without permits and without conforming to the same laws that I file and fight for. So, for purpose of a motion, the Planning and Development Commission finds application number V-2025-00001 inconsistent with the Citrus County Land Development Code and is not in keeping with the intent of the policies of the Citrus County Comprehensive Plan, and that this board denies the application based upon the evidence and testimony presented and the staff report and the conclusions regarding this petition.
Second.
So we have a first by myself, a second by Commissioner Bramlett. Any further discussions? All in favor, say aye.
Aye.
Any opposed? Motion carries 7-0. All right, Madam Attorney, it's all you.
Well, good morning. So you have, thank you. Wow. So you have 2 PowerPoints in your packages that I prepared. I don't know if you've had a chance to look through them. I'm happy to go through the PowerPoints. From the questions that I've gotten from y'all, I think that there might be more interested in the second PowerPoint than the first PowerPoint, but I'm not sure. So I'm kind of leaving it up to y'all if you want to do how y'all want to do it. If y'all want to go through it start to finish, we can do that, or I can field questions, however y'all want to do it.
So Denise, first thing is that
I had a feeling you were going to have something to say.
I couldn't even get a word in.
I know.
I was simply going to say, just from a mechanics, your packet, I cannot open your packet on my phone.
Okay, just 1 second.
She doesn't have this and this anyway.
Okay, well, then it's fine. Leave it. We're good. Sorry.
I cannot open your PowerPoints on our device. And we tried here again collectively this morning, so we can't open them. And it's saying
You
we
can't see the pages?
No, we can't
No.
open them. So what it's saying is we can't connect to the Wi-Fi.
We did not know that to tell us, because we wouldn't try to resend.
Could you do it at home? Or you
Yes.
just
Yes.
have okay, so you just can't do it here.
I can't do it here. I did on my computer.
We might be able to do it with Wi-Fi if we have a Wi-Fi connection in this room.
We do.
Wi-Fi.
There's Wi-Fi here.
Uh-huh.
It's, actually, the Wi-Fi isn't connecting. For some reason,
Yeah.
mine popped up, I think because maybe I had opened it already, I don't know. But, yeah, I'm not showing Wi-Fi.
Well, let's find out about the Wi-Fi.
No problem. You could open this at home, right?
Could you open it?
You could open it at home.
Okay. I have it offline and I'll open up here.
Opened, but I didn't go over it. I don't know. Maybe because I had already brought it up, so.
Are you on BOCC open?
Yeah, I'm connected. Yeah. I have been since this morning.
You have to go in every time we connect.
It says BOCC public, actually.
All right, well, you've got it up there, so.
And BOCCW is working too.
Thank you, Kat.
Well, my
Okay.
suggestion is to start from the beginning, and then when
Okay,
we have
all right.
questions, we'll interrupt you.
Okay, great, because I know some of you have questions. All right, so I'm sorry we haven't done this course for a while, and we have new members that maybe would have liked to have this sooner, so I'm glad we're getting it done today. So this is your short course, as I like to call it. I'm going to go over the roles of the participants, the laws applicable to your decision, and the types of decisions you're going to be asked to make. So the role of the participants. First, you're going to have the applicants. We had an issue recently where we were unsure of whether the applicant could speak for the owner. When the applicant files and the owner signs off on that application, the applicant then represents the owner and is responsible for, the owner is responsible for whatever the applicant has to say. You'll have consultants, you see those often. You're going to have engineers, land planners, I'm trying to think of what Mr. Gibbs is.
Landscape architect.
Landscape architects, architects, things like that. You're going to hear from a lot of those. And some of the mining issues, we have blasting consultants, I know. Those are always interesting. You're going to have the attorneys. You know, we have a few frequent flyers that you're very familiar with, but we also get some attorneys from out of town that come in. So remember that when the attorneys are talking, what they're providing to you is arguments. One of the most frustrating things sometimes for those watching is that attorneys talk and they don't have any witnesses with them. Well, under the strict interpretation of the law, you have no evidence before you because what a lawyer is saying is not evidence. So unless a lawyer brings forward one of those consultants or brings forward a witness or an applicant and has them testify, whatever the lawyer is telling you is not true. So whatever the lawyer promises you is also not, you can't rely on those promises. So you absolutely have to have everything in writing, either as a condition or somehow part of the application because what they're telling you, you can't rely on. I know it's frustrating because many times lawyers come without witnesses. A few really skilled lawyers that we have come before you do bring witnesses with them, and those are always appreciated. You can't base your decision on the argument of counsel. You must have factual testimony. And the factual testimony is going to come from those engineers, planners, environmental folks, witnesses that they present.
So, quick question.
Mhm.
If an attorney does come and is presenting an application for an applicant, you're saying we cannot take their discussion as testimony or witness, then you could only rely on the written word in the application itself.
True, as long as it's factual information. So like a site plan. You can rely on the site plan, but you can't rely on whatever the lawyer is telling you. I know it's very counterintuitive because we often see lawyers without witnesses, and it's very frustrating for those that understand the law and know the law that the lawyers don't bring witnesses. But
So the question I would ask you is, if in fact an attorney shows up without, representing a client or representing an applicant, and in fact you can't count on their testimony, why do we go forward with this process?
that's a good question.
I mean, we seem to be stuck.
If I were in your seat, I would probably ask the lawyer if he had a witness with him. But, I guess I can say that because certain people have been doing it for so many years and no one's ever called them on it, they don't learn and they don't do better, so.
What if the lawyer's like a real estate broker or something like that?
It doesn't matter. A lawyer is never sworn, and a lawyer never gives factual testimony. If you ask Clark Stillwell to raise his right hand and take an oath, he would tell you he's a lawyer. He doesn't have to be sworn. Rob Batzel doesn't have to be sworn. That's what they would tell you, but I'm telling you what the law says. No one's ever challenged it.
But
So-
anyone can be an applicant. Just because they're an attorney doesn't preclude them from being an applicant.
Correct.
Right.
They can all be applicants, but you can't rely
Well,
on
that
the.
was his question.
Well,
He said if the attorney is the applicant,
no, actually,
Well, what I,
There's two things, at least two things in motion here, right? So one is the attorney's representing an applicant, and the applicant's not here, and basically you're saying you can't rely on the information provided by the attorney. My follow-up question was, if the applicant has signed the application, then the only thing you can rely on is the written word in the application.
yes,
And the other guy's providing color commentary.
argument.
Argument.
He's providing
Fair enough.
argument.
So, different than if the applicant is also an attorney, I understand, that's a different case.
I don't think it is. I think that the applicant, if it's an attorney who is the applicant, they should still provide factual testimony. They didn't draw the site plan, I can promise you that. So whoever drew the site plan should be here to testify to you about the site plan. The lawyer can't do that. The lawyer should bring out the testimony. Mr. So-and-so, you prepared this site plan, tell me about the site plan. That's what lawyers do.
So, as a question, I'm not pinging on you.
No, it's
Why
okay.
wouldn't you, as the attorney representing the commission, say, sir, if you have no witnesses, you're just presenting this application and no testimony?
Probably because it's gone on for so long before I ever sat in that seat, I'm not gonna be able to change things.
Okay.
So if an attorney comes forward who has a long history with a project and he gives you all this information, you just should disregard that?
You can't base your decision on it, absolutely not.
How would you introduce that into evidence if you were an attorney and you wanted to make that?
If I was presenting a case to this board, I would have witnesses. I would have my engineers, I would have my consultants, I would have them present the application. I would be there to show how the facts that I have gotten out of my witnesses comply with the law. I would tell you what the law is and how what they're saying does or does not comply with your comprehensive plan and your land development code. Because I know, as an applicant, I have the burden of presenting to you the facts that establish that my application meets the land development code and the comprehensive plan under the Snyder case. And unless and until the applicant satisfies that burden, nothing else needs to happen. The
So
staff
basically-
doesn't need to present, the county doesn't have to refute what the applicant says until the applicant provides sufficient evidence to prove to you that they meet the requirements of the code.
So the attorneys basically steer the process, consult and guide the applicant, but
Yeah.
it is the burden is on the applicant to present factual information related to whatever they're before this or even the Board of County Commissioners.
Yes.
Okay, that's fair.
So that would be strictly more like quasi judicial. It wouldn't be like how about on like a comp plan amendment or where they're.
A straight-up comp plan amendment is
Yeah.
not quasi judicial, it's legislative. But in this the way that we do things, we always have a comp plan and an atlas together, so that's what makes them quasi judicial. We
Okay.
very rarely ever have a straight-up comp plan.
Right. And then
amendment.
how about when the attorney who's making the argument also supplies in the application a written report, but it's from the attorney? We do have some that do that. Would that be considered then part of their argument, and we would have to not consider that?
That concept is so foreign to me because I don't know how a lawyer could testify to a drainage, unless they were also an
Yeah.
engineer or they were also a land planner. We actually are dealing with a lawyer who's actually an AICP. So if that lawyer came before you as an AICP, could take the oath and give you
Okay.
testimony, that would be okay. So
Right.
if that were to happen, you could take the testimony, but I don't know of any
Yeah.
lawyers that,
Oh, I was talking about the written, sometimes they'll make application and part of their application will include their letter with
A narrative.
narrative.
like a narrative.
A narrative. Thank you, Joanna.
They're still just
Okay.
checking the box. To me, the narrative is simply, this is how our application meets this provision. This is how our application meets that provision.
Yeah.
So that's where they're tying the evidence to the law. So I get that, but I would still say they need to have a witness.
Okay.
And I can just say, I've been doing this 10 years here, and before that, was involved in land use decisions here, this is the way Citrus County has always done it. And I'm always still gonna bring it up, because the first time we get a lawyer on the other side that challenges something, we are vulnerable to that. And I know lawsuits that came before I was the county attorney, brought those issues up.
Vulnerable in what way? Precedent?
Vulnerable to having our decisions overturned,
Because?
because you have no evidence. Your decisions are
understand
supposed
that.
to be based on competent and substantial evidence provided at the hearing.
Right.
So if there is no competent and substantial evidence, because all you heard from was a lawyer,
Mm-hmm.
then there is no evidence upon which you can base your decision.
Okay, that
What
clears
about
that.
if it's in the staff, before it comes to the public hearing, if it's in the staff report?
The Snyder case says that it is the applicant's burden of showing, before the staff even opens their mouth or even provides their first piece of paper, they have to prove that they've met all the requirements of Land Development Code and the Comprehensive Plan. So I would say you don't even get to look at the staff report until after the applicant meets their burden. Now, do I think that we're gonna stand here and present everything on one side, wait and think about it? No, I understand that that's not how in real life it works, but I'm just telling you, under the Snyder case, that's the way it happens, or supposed to happen.
What year was the Snyder case?
I wanna think 95, maybe?
Okay. Wow, okay.
I really, I can't be sure about that, but it's been a long time. In fact, our, when did I got to the county in 15, Halls River Retreat was 2000. So Snyder was absolutely before 2000, because was Halls River in 2010?
No,
It was
it was in the
two-
90s.
2000, I think it was 2000.
But didn't the Snyder case, one of those cases made, for one time they were talking about only attorneys should be able to present. Do you remember that?
No.
And that the attorneys felt like lay people shouldn't make.
No, not attorneys, expert witnesses. There is a line of cases that talks about that lay witnesses shouldn't be, their testimony shouldn't be counted. Then there was follow-on cases that said, well, lay witnesses can't give expert testimony, but they can certainly give fact testimony. Like,
Right.
if I know that I've come to this intersection for the last 20 years and there's been no cars, and now, after such and such happened, now there's, hundreds of cars. That's a type of fact that can be accepted by the board, because even though they're lay, a lay person can observe traffic, so.
Firsthand observation.
What
yes.
kind of facts can't be presented?
Can't be presented,
That cannot be, that we can't
consider?
consider?
Any fact that's properly testified to before you, you can consider, and then you have to assess the credibility of the witnesses and give due weight to the witnesses. So, this person, the body language, the mannerisms, you thought they weren't being truthful, you would give them less weight than this person. You're acting like a jury, and if you think of yourself ever sitting on a jury, you look at the witness. Are they nervous? Are they shaking? Do I believe them? That's what juries do, and that's what you do in that role, is you assess the credibility. So,
But if the information's in our packet, is it a fair game to ask any question that's pertaining to what's in the packet?
any question, so long as whatever question is something you're legally supposed to make a determination on. So if the code says, like, for example, you've got the factors under the variance, you've got the 8 or 7, it's either 8 or 7 factors. So long as your question relates to one of those 7 or 8 factors, because that's all you're supposed to base your decision on, right? In a variance, for example, then yes, you can ask that question. But it's gotta go to the law. You can't, why is your hair blue? That has nothing to do with what you're supposed to be relying on. So that's not a question that I would think you could ask.
Well, the reason I asked is because, you weren't here, but I got a gag order placed on me, kind of, sort of, at a hearing recently.
Still upset.
Yes, I'm still obsessed with that
I'm
because
upset.
I'm upset with it because I wasn't able to ask questions that was in the packet. And I didn't prepare the packet. The packet was prepared prior, so I wanted to ask questions that had in there. I wanted a little bit more specifics because that was something that would consider myself an expert on.
Well, first of all, you're not allowed to be an expert on anything.
Well, I know, but in my mind, we all can make believe everything, right? But I just had questions, and I was shot down saying that by an attorney with no witnesses.
But also by your professional staff.
Right.
Right. So
So I just want to know what the limitations
just
are.
because, how shall I say this? Applicants put a lot of stuff in their applications. A lot of times they talk to you about economic factors, like, oh, we're going to bring in X number of jobs, for example. Or, oh, this is going to help your tax base because, we're going to build this grand thing and it's going to increase the revenue to the county because we're increasing your tax base. Types of information like that are irrelevant to your decision because nowhere in our code does it say that we are supposed to consider how many jobs a business is going to bring in when we're making a land use decision. So I wasn't here for that meeting, but you and I talked about it afterwards, and I think the questions related more to signal strength or something like. I can't even remember what was it.
RF and EMS.
Oh, right. Nowhere in your code does it say that you're supposed to consider that when you're approving or not approving a tower. So that's why your questions were irrelevant.
Well, I wasn't considering it. I was just answering a question that she had missed, was not correct in her packet. And that was where I was going to let her know that that's not correct. And then before I can even ask the questions, I got gagged, so to speak.
I probably would have asked her where her witness was, but.
So there's a
We know that now.
Not related to Rick's question, but if you have the presenter of an application identifies himself, non-attorney in this case, identifies himself, and we have a number of consultants that come in and speak for the applicant. Do we consider that presenter in the same role we would consider an attorney, where
No.
they're simply presenting factual information?
No, absolutely not. If you get a Paul Gibbs up here, each application, you could ask him to tell you what his credentials are. But I think he's appeared before us so many times that y'all know who he is and what he does. So he absolutely gives factual testimony. He's not a lawyer. Lawyers are different. They're a whole different, we are a whole different category of people. We never give factual testimony. We only represent our clients or the people that we're here representing. So
the only exception we're making is attorneys by their profession.
That's
as
what I got up
compared-
there.
Well, I'm cleaning
black
up in
and
my
white.
mind, not in your mind, my mind. But what we're basically saying then is other people are coming and presenting. We have to judge based upon number one, their credentials, and number two, the information they present and how they present it, if we believe it's creditable input.
Right.
Because none of us sitting up here, well, I don't think any of us sitting up here are stormwater drainage experts or, retention area design experts or capacity of, these kinds of detailed questions that are made, they're key to the land use. They're key to the decisions we make, but we have to rely on the information presented.
Right. So, for example, if you have a staff report and the staff report brings in comments from technical services about stormwater, and you have an applicant here that doesn't address the stormwater, then you have no evidence from the applicant. You don't have any consultants, no engineer types that are here telling you that the stormwater system is going to work, so to speak. Then the only evidence before you would be the staff report's technical services comment.
Okay,
commentary.
I'm going to hold this, thank you. I'm going to hold this question later. I understand that when presentations are being made, we have the applicant on one side, we have the staff representing the county, the county technical expertise on the other, and we are adjudicating between the two.
Mm-hmm.
So can we count on county staff information? And the answer is, of course we can. But those are the two opposing forces. They may be opposing, may be, in sync, but basically we have two parties here. And we are not counting on staff to be our eyes, ears, and research into this. We're looking at what the applicant presents, what the staff presents, and then making a decision.
Yes.
And you might have people in the audience.
The
that want
public,
other-
yeah. Which
Yeah, you
could
may have
an
intervened-
attorney that lives there. At that point, I would think, though, he would not, that would be different in that case. If you have to have a neighbor that comes in as a witness, either as an
Yes.
opponent or proponent, but he happens to be an attorney,
Right.
he's still, at that point, considered a
Yeah,
witness.
we get to be people
Yeah.
sometimes,
Yes,
as long as
okay.
we're not here representing somebody. If we're just speaking about, our neighborhood, then yes, we can do that. Okay,
What about written evidence?
what about it?
Like, what if the engineer isn't here, but a signed and sealed document from an engineer was provided?
You give the evidence the weight you believe it's due. So if you have a piece of paper that says one thing and you have a live witness that says another thing, then it's up to you to decide whether you believe the writing. If you can't cross-examine a piece of paper,
Yeah, right.
right? So you give it the weight it's due. I mean, I understand costs and I understand expenses. So I understand that, bringing witnesses here, experts here, it is expensive. But, you kind of look at the size of the project, you kind of look at what they're asking for, and you couldn't pay your stormwater person to be here, if it's that important.
Okay.
So will you touch
I
on,
wouldn't bring a case forward without witnesses if it were me.
will you touch on concurrency at a later point?
Sure, we're only on slide 2.
Well, we're moving right along.
Oh, we are.
Well, we're not trying to outthink you here, but if concurrency's coming up later, I'll hold my question. If it's not,
Concurrency, there is nowhere in any of my slideshows, so you decide when you want to ask me about
right, so an
concurrency.
applicant comes in, and every applicant, when it comes to concurrency, is providing some letters from some department or entity.
Well, we only
water.
have concurrency for 4 areas.
Fair enough. Want to say what those are?
Solid waste, stormwater, water and sewer.
And sewer.
Water and sewer,
Okay.
sorry.
So an application comes forward, and they have a letter from a designated representative from the water. Which
Provider,
is called
the water provider. Mhm.
saying there's sufficient capacity.
Yes.
And so one of the questions that I have asked, and I'm not even sure I can ask, I said, in this moment in time, when that letter was written, whether it might be 2 years ago, there was sufficient capacity for that particular application based upon their needs. But nowhere does it address what the system's capacity is and in what potential changes or upgrades would be required to the system. In concurrency, and I'm not sure how this impact fees are gonna change all that, if any at all. But,
Two
but
different
when
things.
does an applicant then, when do we understand that the applicant is charged with the responsibility of seeing that that system is expanded to meet their need?
Well, an applicant wouldn't expand the system to meet their needs.
Or pay a
It's-
fund, make some monies in terms of a contribution to fund an expansion.
So I think at the time you make your decision, you base it on whatever the provider has told you. So the provider has provided a letter and they've said they have acceptable capacity. If after the first 5 homes are built or 100 homes or whatever, all of a sudden they don't have capacity, that's on that provider to have to upgrade their system or do whatever it takes so that they can provide it. That's not between us and the developer or whomever it is, as long as they get that letter. But I'm pretty sure that the applicant or the developer is gonna have a problem with the provider if they've told them they can do it and then they don't. But that's not between us. We're not involved in that.
So oftentimes we hear comments from the public, well, look at the road, look at the condition of the road. The road's not sufficient in terms of its number of lanes or its underlying structure. It's gonna have to be rebuilt. or they're gonna build something down the road, or something's being built down the road. Since roads are not part of concurrency, what weight is that given? Or do we need to make an assumption that other people more knowledgeable in roads, expansion of roads for the county, are taking those factors into consideration?
It's not relevant to your consideration because we don't have concurrency for transportation. So back to the same question here. Thank you for your comments.
But what happens if it involves public safety?
Right. Health, welfare, safety, that's what I was just gonna, I was
Well,
gonna ask
he's
the same
talking about
thing.
lanes and condition. That's not
Concurrency.
safety.
Okay.
Oh,
Like-
turning lanes, stoplights.
Well, we do look, I mean, our technical services do look at, I'm drawing a blank.
Access
Access
management.
thank you, access management. So if it has to do with access management, turn lanes and things like that, then we do look at that. But if you're talking about simply, there's gonna be more cars on the road and it's, traffic's gonna be terrible. It's not ripe for your consideration.
I mean, there's a lot of cases where they allow things to happen where you don't have any infrastructure at all. You know?
Yes.
Inverness Village 4 is an example. I mean, you gotta.
Not discussion for today.
I don't really know anything about Inverness Village 4.
But I mean,
That was a joke, for the record, that was a joke.
there's a gray area there.
I don't think there's a gray area.
Yeah, it's either on there or not. Move on. Let's go to slide 3.
Okay.
Thanks.
We've talked about that. And then, of course, the other people that may appear before you are the owners and sometimes buyers. We have definitely had some buyers show up and they're interested in sometimes, we've had actually a lot of this. They will have a contract with an owner contingent upon them getting, whatever it is they're asking for. I'm sorry, I made it seem like we didn't, but I'd say that's probably a 50-50. So a lot of times, well, anyway, I'm not going to speculate. Understanding the role of this, and of course, staff. And as Mr. Shera said, a conversation he and I had, and why he said that is because some would think that it's not clear of the roles of everybody. And I get to it, but I'll bring it up now. Remember, staff, you have an applicant on one side and staff on the other side. Those are your two parties. Generally, sometimes you have the interveners, and then, of course, the public. Now, the public is not a party. There's a case directly on point from the 5th DCA, which is our DCA, so we have to follow it. There's no getting out of it. The public are not parties, but the public can provide testimony to you. They can provide facts to you, but they are not parties. My role in these hearings, in case you didn't know it, is to represent you all. I represent this board. I represent the special master in code compliance cases. I represent the special master like when we had the mining application, and I represent the Board of County Commissioners. Staff at these meetings does not have an attorney with them. At code compliance cases, we do have a lawyer that sits in with staff for those. The mining case, we had staff, a lawyer sit with staff. So generally, our staff comes without a lawyer to these hearings. Not by choice. Sometimes. Our staff is very competent and don't necessarily need lawyers. But just so you know, I am here for you, only you. I do not represent staff at these hearings and sometimes disagree with staff, and of course that doesn't always go well, but we'll move on. They're your experts and your professionals. Well, not yours. They are the county's experts and professionals, and they provide factual evidence. You can base your decision on what staff tells you. This one I put in here because it is important to know that before anything ever gets to you, there are countless hours spent between the applicants and staff to try to get a package to you that's comprehensive and that provides hopefully all of the information you need to make your decision. And then, of course, there's me. You can ask me questions at any time. Anytime. During your deliberations, before your deliberations, before meetings. Some of you have availed yourselves of that. You'll call me. Please, no texting on county phones. If you need me, call my office, send me an email. I'll get back to you as soon as I can. And I do look out for the county's best interest. This is sometimes is misunderstood. I don't represent you individually. I don't represent the county commissioners individually. I represent the county. So if one of y'all or one of the commissioners is about to do something adverse to the county's best interests, I'm obligated to tell you that. Sometimes that doesn't go so well. The board members, just so you know, the PDC is a statutorily required, let me rephrase that. The statutes require we have a planning board. That planning board can be made up of members like yourselves, or it can be made up of the Board of County Commissioners, as long as they have an opportunity for the school board to sit on that board. In Citrus County, we have the PDC. The public, we've talked about the public. They're not parties. They provide factual testimony. Their testimony may be used as a basis for your decision, but with the caveat that they can't give you expert testimony, only lay witnesses. When the public is talking, I encourage you all and the Board of County Commissioners not to challenge the public. Just accept what they have to say. In the past, I know we have had board members that wanted to argue with the public, whatever the public was saying, they wanted to disagree or debate with the public, and that really should be discouraged. They may or may not be sworn. Sometimes the applicant will ask that all witnesses be sworn, and sometimes they don't. It is strictly up to the applicant to decide whether or not they want the witnesses sworn. That's in our quasi-judicial ordinance.
What does that mean? Swearing a witness, that just means they're swearing
Take
on
an
telling
oath.
the truth?
Take an oath,
And
yes.
if they're not sworn, where you can just say, maybe some of it's BS?
You can.
I always
That's
assumed
assessing the credibility of the witnesses.
So we've never had an applicant go, I want my witness sworn. I want them to swear.
We have.
I don't
We
know about
have?
ever.
A few times.
Yeah, a few times.
The more controversial ones, the applicant, usually an attorney, will want all witnesses sworn.
So like if a witness says something, I can say, well, would you swear that testimony in?
No, you can't.
Do you feel comfortable
I just-
swearing that testimony in?
No, I just said the only person who can ask for witnesses to be sworn is the applicant.
What if
So-
you ask the applicant and I say, hey, Mr. Applicant, you've got some witnesses bringing some testimony here that is pretty interesting and it maybe have some bearing on my decision. Would you mind having those witnesses sworn in?
I would discourage you from saying that. You just give the witnesses the weight that it's due. If you think they're not telling the truth, that's within your purview as a juror, as somebody who's assessing the credibility of the witnesses, you get to do that. But I think it comes off as very adversarial when you're challenging them, if you will.
Is it a challenge or is it just a, hey, if they're truthful, then
Sounds
swear it in?
It sounds challenging to me.
Yeah.
Does it?
Yeah.
Maybe I can reword it. I'll work on that.
It's as my mom always says, it's the tone. So the laws applicable to your decision is the Constitution, federal and state. I'm not going to quote that. Nor shall private property be taken without just compensation. So we can't, you can't unreasonably restrict someone's use of their property. That's considered a taking. Fundamentals of fairness and due process is a big one, and it's where we wrestle with ex parte communications, and it is implicating the due process rights. When someone wants to challenge your decision, one of the easiest ways to challenge your decision is to say that they were not afforded due process, and that could be they were met with a partial decision maker. That's a big one. And where we sometimes get into trouble with that one is when we use our own personal knowledge and biases and prejudices when we're making a decision. If we know something because of our background, we don't have any surveyors on the board, so I can use that as an example. But if you're a professional surveyor and you're looking at someone's application and you as a professional surveyor, you know that there's errors in the survey, You're not supposed to use your professional background. You're supposed to use common knowledge. You're a reasonable, you're reasonable person when you're looking at it, not at your professional. And so sometimes you get that bias, or you'll hear that, some board member will say, oh, I read that in the newspaper and I didn't like that, or I don't like the kind of business they're doing. Those are the types of things that someone can argue about due process, and definitely the ex parte. That's a big one. Statutes, planning and zoning, they are appropriate. You have to make your decisions on a coordinated basis. So, we all know what zoning is: the allocation of land by major function performed thereon. Some people think that zoning is a bad thing. Some people think it's a good thing. It doesn't really matter. The law says that government can have reasonable zoning. Rely on objective. Same kind of thing. You want to be fair and equal. Comprehensive plan, it's required by statute. Establishes meaningful and predictable standards. That helps everyone. It helps both the county and the landowners because they know what they can and can't do to their land. It also helps neighbors because neighbors have the reasonable expectation that they can rely on what's in the comprehensive plan. So, if I'm living up north somewhere, I'm going to retire in 15 years, and I buy my slice of heaven in Florida that I intend to retire to, they have a reasonable expectation that the zoning is not going to change behind them to some, noxious type of activity if when they bought it, it was zoned residential behind them. Everybody gets to rely on zoning, and that's why when you change zoning, there needs to be a really good reason why you're changing it once it's established, which we absolutely have established zoning in Citrus County. It's a primary planning tool. Remember, you did ask me. So in terms of hierarchy of documents, our most important document, the most cherished document is the comprehensive plan. Everything coming below it has to be consistent with it, which would be the land development code is next in line. And then if there's any rules and regulations that come after that. So comprehensive plan is primary, land development code is secondary.
What about the G-flume?
The GFLUME is part of the comprehensive plan.
Okay.
The land development code atlas is part of the land development code. So I think in your question, you segregated those out, but the GFLUME is a part of the comp plan. Chapter 10? 10. Chapter 10, and then land development code, I don't know where the atlas is. Chapter 2.
Well, the districts.
Yeah.
So where we had a recent application where the GFLUME representation in terms of a particular area was one designation, zoning was another designation, and that was somewhat confusing. No, that was confusing. And
So,
then-
sometimes it happens because the way it's explained, or the way I've heard it explained, is that the GFLUME is where we want to be in the future or over the planning horizon, whatever the horizon is for the GFLUME. And then the land development code might be where we are today, what we would like to move into. It can't be inconsistent with what's on the GFLUME. And a lot of, I don't know if Joanna wants to, or Eric wants to help me with this, but a lot of the land development code was done with what was existing at the time that we first adopted the zoning map. And so the GFLUME is the overall where we want to be, and maybe today there's something here that might not be completely desirable, but it's going to go away over time. So I don't know if that's really
I need more on that. I need more understanding on that.
The comp plan and I'm sorry, I'm jumping
No,
into your
go
thing.
ahead.
They should not be identical. They're not supposed to be carbon copies of each other. The comp plan used to show only things that were 10 acres and larger. And then 2012 or so, we actually tried to make them more parcel specific, but you still have those inconsistencies. The comp plan is the rule. So if somebody looks on the LDC, for example, and it says GNC, and they go in the comp plan and it says RUR, it's RUR. And they got a problem because they're inconsistent, and they're gonna have to fix one or the other to develop that. So she's right in a way that it's kind of what we want, but it's also more of an overbroad view of the county, whereas the LDC is very specific. It shows where mobile homes can go, and it shows a little tiny sliver of CLC because it's been commercial since the 80s. But in a future land use, probably that might not show that. So that's the differences. We have the big, huge Bible, and then we have the very, very detailed. Does that help?
So how does that change? Like something burns down, we have massive fires, things that have happened, we've seen happen in the world recently, and now they're trying to say, oh, we're not gonna put back what was there, we're gonna put back X. And people are going, ah!
Right.
But that's because the future land use, the past went away. The people that own that property still own that property, but now they own that property based on the future land use.
Well, no, that's why when you say future, it's not great. It's actually just more of a general idea. It's not really, we want this in the future, and now this is what we have. That doesn't work. And it's kind of more of an overview of, you can see the conservation, you can see the CL areas where we're trying to protect, but when you go into the more detail, you'll see the individual. We don't very, very rarely does the county change someone's land use for them. And if something happens, it's a big deal to do it.
Well, let's not say that, because we have these corridor studies, which absolutely changed people's
They give
zoning.
them a little bit more options, but they still have to come through a comp plan amendment and Atlas amendment in the IMAs at least.
But you make them non-conforming.
No, the IMAs are very specific. They can't create nonconformities. We're very specific about that.
Senate Bill 180.
Don't even start on
Yeah, don't
that.
even start about the new bills. Yes, so we don't change people's zoning. They come before you to do it. So the fact that something burnt down isn't going to change their zoning at all. If they decide, that's what I had before, but now I want something now, they got to look at what their current zoning is and their current land use, and it might not work, and they might have to come before you. But we don't usually change people's zonings. And the IMAs are designed specifically that if you are on Cardinal and you have rural now, you can continue rural till the end of time. But if you want to use the new land use on Cardinal, you have to come before you guys and before the commissioners and change it. We're not going to do it for you.
And it's based on the infrastructure. You're gonna have the infrastructure to get to the higher density.
Perhaps.
Yeah, when we have concurrency, but yeah. But water and sewer, yes.
It's water and sewers.
Water and sewer is one of the things in our comp plan that says if you want 40 units an acre, you have to have central water and sewer. That's not in our land development code, that's in our comp plan. It's a rule, it's a Bible. That's the really hard rules there you can't get variances from.
Okay, and land development code. They implement the standards contained in the comp plan. Remember, the comp plan has very broad language. The policies are very broad. And then, what do you have, 90 days? After a comp plan change, how long do you have to change the LDRs?
Oh, I don't know.
Anyway, there's a
Wow.
specific, when you make a change to the comp plan, you have to make sure that your LDC is consistent with it. And sometimes the LDC has to give the nuts and bolts to see that the policies in the comprehensive plan are carried out. This is a big one. We need you to rely on the objective criteria in there. For example, like with the variance, you have the 8 or 7. I'm sorry, I don't know how many. Is it 8?
Yeah.
The 8 criteria. Those are the criteria you're supposed to use. You're not supposed to, what did we do last time on something like this? The big one right now that we're dealing with is this idea of an overall project-wide ISR. Nowhere in the land development code is there anything about a site or a plan-wide ISR can be higher than what is required in the actual LDC. Applicants are telling you, well, you've done it over here. Here's a chart of how many times you've done it, so you need to do it this time. Well, you probably shouldn't have done it the first time, and each time after that, you probably shouldn't have done it either, but it is what it is. So that's something that is not part of the objective criteria.
Question for you, ISR, were you coming to that later, more detail?
No, go ahead.
So if we have ISR and we look at it, my understanding is ISR is on a site basis.
But by land use.
By
But
land.
zoning sets your ISR.
Zoning sets your ISR, and we have applicants that want to talk about ISR on a lot basis.
I think it means project basis.
On a
Project
project
basis.
basis,
Yeah,
yes.
that's what I just said.
No, so actually, I'm not articulating here. So they want to look, we've had applicants or developers look at it on a project basis, but break it down into individual lots. So I'm trying to, so you've got a project and there's an ISR. But they also want to say, but no lot shall exceed, or individual lots could exceed to a certain level that is beyond the project-wide ISR.
I know what you're saying, but you're not, I don't think you're saying
me
it the
out.
way you want to. The Land Development Code sets ISR on a lot basis, per lot basis. It does not set it on a project-wide basis, a site plan-wide basis, at all. It simply says if you're an LDR, your ISR is X. If you're GNC, your ISR is X. What applicants are telling you, or what they're asking you, is, hey, we know what the LDC says. We know we're supposed to, we're an RUR and we're supposed to be X. We know that. However, in the past, what y'all have done is you have, gone site-wide or plan-wide or section-wide, and you've allowed us to, increase beyond what is the LDC requires. So would you please do that here too? But nowhere in the LDC is this idea of, whatever, plan-wide, it's ISR X, which exceeds what the LDC requires.
But we're not obligated to, based on what
You're not
10
obligated
years
to.
ago happened.
No, you're not obligated tomorrow. If we had another meeting tomorrow, you're not obligated tomorrow to do what you did today. I would tell you, the applicants are going to tell you, well, that's not fair. That's not fair. You did it yesterday. You should do it today. I would tell you, you shouldn't have done it yesterday because the LDC doesn't allow you to do that. But no one's challenged. It always comes down to that. Unless and until someone challenges something, it stands. So,
Because it seems like an awful lot of these applicants that come before this and/or the Board of County Commission, it's almost always included in one of the variances they're looking for.
deviations, yes.
Deviation, call it.
Of course
Yeah.
it is, because they're
So-
gonna tell you that they can't make ends meet. They're gonna tell you, putting in the infrastructure costs so much that we need to get more money out of each lot, so therefore we need to cover more of the lot. That's their position.
True. That is accurate, from a financial standpoint, I believe. But at some point, somebody's gonna have to lay down the law. And good luck with that.
So I've usually seen those in PUDs, which do have deviations, and if they're doing cluster housing on smaller lots, they'll want maybe a higher ISR with the premise that you're right, that the overall master plan, because it has so much open space, is gonna actually bring that ISR down on a overall basis. And of course, if they're going through their stormwater management and all that all has to be calculated in. So in that case, wouldn't that be necessarily appropriate, as long as there's nothing in the comp plan that tells us otherwise? Or-
So, if the LDC said, when you do a PUD, if you want to, a different ISR, we could apply these criteria because of the policy reasons you've expressed. Unfortunately, the LDC does not have that. So,
That's how Meadowcrest came about.
Yeah, a lot of them
That's how-
back in the day.
But I agree
Yeah.
with that. I agree.
It's hard for staff
It's-
to calculate. There was no way. You just basically had to go by the fact that, okay, well, there is a lot of open space and it's part of a master plan, and the development is being consistent with the master plan, but
And they
that's
come
all
in
you
and get
had.
Variances on individual lots after they've been given
for ISR?
Not anymore.
Not
How do
anymore.
you get a
Thank you.
variance for an ISR?
Okay, well, that was a certain administration that allowed that, and I disagreed with it because I felt that it's a master
Where's the
plan. It has
hardship?
to adhere to the
Where-
master
ha-
plan.
What part of our
Yeah.
slideshow is, in order to get a variance, you have to show a hardship that is incumbent to the property, the land.
Yeah.
Why would anybody get an ISR variance? I don't know, sorry, okay. That, not now, we don't do that. Okay. So if the Board of County Commissioners and this board wanted to change the law, change the LDC to allow these types of percentages, then you would have you'd have something objective in the code. If you are doing a PUD and if you want to thus and such, then, you could get a 55% ISR in a thus and such land use category, or you could get a 60 or whatever. It's just, applicants have the right to know what's expected of them, and the law, the county has the right to know what people are going to ask for. But when we're all over the place, it causes uncertainty for the applicants as well as the county. So I agree with you. It's hard. It's hard. So maybe that'll get fixed. As you know, the Board of 180. The Board of County Commissioners is saying that they're going to look at the LDC and the comprehensive plan and do an overhaul, if you will, or an update. And I think we have a workshop coming up at the end of August to discuss that with them. So that might be something that they might address, and that would be helpful if the policy decision was that we needed to change that. Oh, we have no authority to add or subtract. We just talked about that. Your personal experiences or opinions outside of the record are not to be relied upon, so the surveyor can't rely on their surveying knowledge. Somebody who's run a package plant at their mobile home park in the past can't talk about whether a package plant is acceptable at whatever applications before them. That's something that happened in the past I like to bring up.
So question.
You know what I'm talking about.
Yes. Well, and we've had applications over the last year talking about, packaged wastewater treatment plants or sewer treatment plants. And, this is and there's been testimony, this is the latest technology. This improves on the previous technology. Then, we're being asked to opine on something of which, other than their representation, there's no technical basis.
So if the applicant tells you something, their expert, not their lawyer, but their expert tells you something, then if staff doesn't offer expert testimony to refute that, then the only thing within your record is what the applicant said, or the applicant's experts. So you have to rely on that. Now, hopefully, if it's crazy, whatever they're saying, that it's absolutely not true, then you're going to have an opposing opinion given by somebody else. And then you're going to have to weigh the credibility of those two witnesses and decide which one you believe.
And where I ran afoul of you was trying to understand what, in fact, was included and what that meant, and then have the ability to go do, I hate to use this word, I'll use the R word, I won't use it.
Independent research?
Yeah, but to try to understand, in fact, what's being presented. Now, we've been told we can't do, we are prohibited from doing independent research.
Right.
So we're sitting here listening to somebody, expert witness they may be, biased they may be as well, presenting that they're going to do something, and because they're going to do it, they've selected the best available technology for the application, and you should approve that. And to your point, unless staff objects and say they've made this representation, we as our technical people have looked into this and we don't agree with that. Otherwise,
Yeah, well, you would hope that when staff gets, you only usually see planners here. Sometimes you see our engineering, technical services staff people come, and when they're here, usually the planning staff needs backup, needs support from the engineering types. That are coming. I know we've had access management, technical services that come to talk to us about access management on occasion. So if they're here, you're going to know staff doesn't wholeheartedly buy into what the applicant's experts are saying. So they're here to back you up. But if you don't have that, then you got to go with what's presented to you. Even if it doesn't pass your sniff test, that's all you got.
Denise, can we say, staff, please have this reviewed by a member of the water department and give an opinion as to whether or not the veracity of what we're being presented here? Can't we ask the staff to go get somebody to do that for us?
Unfortunately, as the jury, I keep bringing up jury. As the jury, you don't get to tell the parties how they should present their case. So if you have questions in your mind, then that's a no, right? Because if something's not adding up to you, then you can't support whatever it is. But you can't tell them how to present their case.
Well, we're not presenting a case, really.
Yes, you are. You're a party presenting a case.
Right. And we rarely do bring people before you, but we do sometimes, and you'll see that. Exactly, we're not engineers. One's coming up in a few months. We're gonna have environmental health here. I can't speak for them, but they're gonna be here.
That's sort of the same though, like part of the staff report will have witness testimony, and it's their expert witness testimony. Environmental health says XYZ. Technical services say XYZ. But that, based on what you just told me on the other side, we just have to determine, okay, do we believe it?
Right.
Do I believe what technical services is saying? Most of the time I do. I feel like we have a very good staff here. I know I trust what Joanna knows and doesn't know and how long she's been here. I feel like Citrus County is very fortunate with that. But there's a lot of times I feel like that I'll say this board kind of gets into the weeds over what septic system is going to do this or what traffic light is going to do that. And in my experience in being here, I'll say is I don't even really look at that stuff anymore. If the staff says it's going to be X and then they say it's going to be Y, 9 times out of 10, I'm going to believe the staff unless they're over here telling me why I should believe them. It's just kind of.
And remember, the applicant gets the staff report, right, before they come here. So that's why we say that rebuttal testimony, when the applicant gets to do rebuttal, they only get to do rebuttal to the public because they've had the staff report in advance. So if they disagreed with something with the staff report, they should have put that on as part of their case in chief, right? When they're making their case to you, they know that engineering said that, a turn lane isn't going to work, for an example. So during their case in chief, they should have their engineer here with the credentials to say, now I know the staff your staff looked at that, but here's why I disagree with what your staff said. So that's why they don't need a second rebuttal, because they should take it. Of course, if staff says something that's not in their staff report, which hopefully that wouldn't happen, and the board would catch that, because remember, they're supposed to have all the evidence in advance of the quasi-judicial deadline, so they're not supposed to be testifying to anything they haven't already explained and done in advance. So,
Yeah, so chairing a meeting when they try and do rebuttal, if it's not rebuttal to anything that is just the public said, then it should be shut down.
yes. And what you see a lot of times is rebuttal becomes closing argument.
Yeah.
Yeah.
It's like, so,
I'll be over here nudging, wait.
just be aware of that.
Yeah. You're done. You're up next, just remember that.
And sometimes it becomes negotiation time. And again, if you guys don't like the whole ISR thing, maybe we can see about getting that changed, if you believe it's a good policy to allow different. We can't change state law or federal law, of course. We can't change the law regarding ex parte. We can't, it is what it is. There is one slight change to that. We could change ours because the statute disagrees with the case law. You took an oath to uphold the laws. That's just a reminder. I'm going to try to go a little faster because we have a whole other PowerPoint. We've talked about the things that you're going to be asked to do: comprehensive plan amendments, sometimes just text amendments, and then sometimes also, they're changing the comp plan to change their designation. You have to think of the impact. And the example I gave, the person who's retired up north, they're going to retire down here. Is it fair to them to have the comp plan changed behind their house when they relied on that? We talked about the flume. You make recommendations on comp plan amendments, both the individual lot amendments as well as the text amendments. They have to come before you before they go to the BOCC. well, they have to come to the planning board, which in Citrus County, you are the planning board. LDC, you do the text amendments also and applicant amendments. You've seen a lot of text amendments. Some staff initiated, some applicant initiated. You've actually seen a comp plan text amendment initiated, that one about the manatee and the cut-in boat slips. That was a text amendment for that one. The deviations to the land development code, we see those in PUDs, variances and conditional uses. I thought it was interesting we had a variance today because we haven't had a lot of variances. When I gave this presentation, probably the last 2 times, we were seeing tons of variances.
Yes.
So I'm gonna zip through that part of the slideshow. But we did have one today, so. Any deviations, this is the paramount. Joanna keeps calling it the big Bible. You can't have you can't waive or give a variance in the land development code if it's inconsistent with the comp plan. There are no variances to comp plan, like 50-foot waterfront setback in a tidal coastal A zone, something like that. This is, again, the applicant's got to show you why the text amendment is warranted, and it's got to be compatible with the surrounding available services and infrastructure, and you also make recommendations to the BOCC. A lot of times I get asked the question of, well, if the applicant comes before us and they dot all their I's and cross all their T's and they meet all the requirements of the land development code, don't we then have to give the relief that they're asking for? And I would say to you that the law says no, because what the law says is even if, so once in the burden of proof, once the applicant brings forward good and sufficient evidence to show you that they meet all the requirements of the comprehensive plan and land development code, then the burden shifts to the county, the government, to show why the change is not within the public's interests. And so that's the, I know there's, local media, news outlets that are, well, so-and-so has met all the requirements of the code, it's a done deal, they should get it. But the law doesn't provide that. The law says even if they comply with checked all the boxes, you still have to do an analysis of whether or not maintaining the status quo is no longer in the public's best interest. So, I know I hear that a lot. Well, they've met all that. Well, but you have to decide if, is that zoning still meeting the public's interest? Is it still a good plan to have it zoned that way? And if it is, then the application should be denied.
That's compatibility, right? Like, kind of what we're talking about? No?
No. Compatibility and I'm not going to get this exactly correct, but, can 2 uses coexist in perpetuity without unduly infringing on the other one? So in other words, do they get along? If we change it to this other use, will they still be able to get along together? That's compatibility. But I'm talking about a public interest type of analysis, which zoning is, government's way of maintaining the public's interest, over the whole course of the county. So you have to look at that one particular change that's being requested, and does that change, even though we've set the law, we've got our zoning maps, we've got all our, every piece of property has a zoning category attached to it. And when we made that decision, we were thinking we were doing the right thing. So if somebody wants to change that, there's got to be an analysis of, is that change still within the public's interest? Because at one time we thought this was what was best, right? We set everybody's zoning category, and we thought that was what was best in the public's interest. Now somebody wants to change that. If they want to change that, we've got to show, why? What's the reason we're changing it? Is it still serving the interest that we initially set out for?
You talked about some of the zoning was just placed because that's what it was.
Right.
Right, so in some instances, that may not be what's best.
Right. That's why you have to do that analysis. Does maintaining the status quo still serve the public's interests?
Right.
And if that analysis is no, it was a fish camp before in the 50s, and that's probably not the best place for a fish camp anymore. And now they're going to make something else, and that's probably what's best for the public's interest.
Does it go the other way too, though? I mean, I can appreciate that, but if they subdivision that's gonna have a lot more impact than how do you see that in terms of the public interest without getting into concurrency?
Yeah, you do the same analysis. It no longer serves the either it continues to serve the public's interest as it is, or it no longer serves the public's interest. You do it, you balance that both ways. And so if the public's interest is uncongested roads, having funding available to make needed road repairs, then maybe it's not in the public's interest to change it. We thought we were gonna have 5 houses there. We could probably handle 5 houses. Now they wanna put 20 houses. Oof. We can't afford 20 houses there. Fire, EMS, roads, ooh, we can't do 10, so no.
It's like the cumulative impact of all that.
Could be. I'm moving along unless y'all stop me. So variances, as we know, I'm not gonna go through all these, the 8. Anybody have any questions about the variances? The things you can consider? Remember, the variances, it's got to be a hardship that is caused by the land, not the homeowner. If it's self-imposed, does not qualify. Some of the things we've seen in the past, yes, is it an irregular lot size? Is the topography? Yes, those are things that may qualify. But, because, my surveyor made a mistake or my contractor, we've had the contractor build the house, over the line. I think we vacated an easement in that case or whatever, but that would not be a reason for a variance under the law. Realtors, we used to hear that all the time. Oh, my realtor said I could do thus and such. Sorry for picking on realtors. And if they don't do their own due diligence, if it was evident to everybody else and they didn't look, it's not reason for a variance. We used to hear, the person that needed the swimming pool because they needed to do physical therapy in their swimming pool. That's not a reason for a variance. I'm just going to zip through these.
A quick question.
Yes.
You've touched on a couple times on bodies of water. One of the questions is whether it's a state regulation, a federal regulation, or just local zoning. There's a setback from the high water established mark or a setback from the delineated wetlands. Is that state or federal?
Well, we have our own setbacks.
County.
We have
Is that
our own
county as well?
setbacks.
County.
But the county has to comply with either state or federal.
State and federal are a lot less restrictive than we are.
I would think,
We're much
yeah.
tighter, yeah. So if they're meeting SWIFT-MUD, great. I don't care. They're not meeting ours. So I just want to add too with these variances, y'all worked really hard on revising the variance for criteria in the land development code, and you can see what's happened. We've stopped seeing the waterfront variances for the most part because you did a really good job changing the code. And also staff is very tight. She mentioned by the time they get to you guys, like the one this morning or any not specific cases, we've talked to them so much. If they come before you with a really crappy application, they've just disregarded staff. That's all it is to it. And you're not seeing the ones that, try the poor health, or I need a pool because I need to, my wife needs to work out. No, and we're steering them away from you. But I think a lot of it can be you guys' credit. The variance process is almost gone because they have a lot of options now. They can do the neighborhood average, which is working so well.
Yeah, these I wrote back when we were having so many problems. This is analyzing the criteria that, irregular lot size topography, yes. The next criteria, they can't have a special privilege, do you want me to go through all these?
We're not really seeing the waterfront variances anymore.
Yeah.
That's what we're seeing. And if there's not a hardship, we try very hard not to bring them forward to you. We try to go through options and tell them there's not a hardship, the chances are very low, what else can you do? That's why you're not seeing them. The one thing I would say about variances, one of the things is,
it also, the test is that they can, they have to be able to make reasonable use of their land for purposes that it is zoned. So in other words, if it's zoned residential, the law says they have a residential house, but they don't need a pool to have to make residential use of a house. We used to get a lot of those with swimming pools. They wanted to add swimming pools even though they didn't fit, and they said, well, I need a swimming pool. That's not really a grounds to give a variance. And I think we had some like I think the person wanted a gazebo, and it was just too close to the water or something. Well, you don't need a gazebo to make residential use of a property. So I'm just going to go through these. You have these materials. Man, I did a lot on variances. Conditional uses. This is important as compared to variances, or similar to variances. You make a final decision on variances, and you make a final decision on conditional uses. So once you decide those, that does not go to the Board of County Commissioners. If they don't like your decision, they have to appeal your decision. And I think that's very important that you realize that. And basically, a conditional use is a situation where it doesn't really fit the code precisely, but in the chart of uses, in Chapter 2, the chart of uses, they are the county has made a determination that even though it may not fit the letter of the zoning designation, it can, with the proper conditions, it can fit. And that's what you see a conditional use. I know we saw those like with some tractor trailers. They weren't really allowed in a category, but when you did they had to be set back a certain area, and they could only be running at certain time periods. They can maybe fit. It's kind of like if you have enough conditions, we can make them fit. And in the chart of uses, they're designated with a C, so they can come and ask you to allow those. They can't be incompatible once their conditions are applied. Sure, in the abstract, it might seem like they wouldn't fit and they wouldn't be compatible, but if you put enough conditions to kind of, shield them off or have working hours, then they could potentially work. These are the criteria in the code that you're supposed to use to determine them. I don't think we have to go through all of these. Anybody have any questions about conditional uses? Anybody? No. Okay. So should I go right into the next one, or do y'all have questions that you want, general questions? I know, Mr. Sherry, you've got a bunch of questions, but I don't know if my next presentation covers them or not.
I'll wait.
Okay. This next slideshow, it was kind of an afterthought for me to put it together. I've recently been getting so many questions about quasi-judicial and ex parte that I thought it might be a good idea to put this together. And basically, what I wanted to talk to you about is, what are the quasi-judicial decisions that you're making? How are they different from the legislative decisions that you may make, because you do make some legislative decisions, and talk to you about best practices in quasi-judicial hearings. It's kind of why I put this together. So, as we've said, in a quasi-judicial hearing, you're acting as a judge, also as a jury, because remember, a judge sometimes acts as a jury when there is no jury. So you are the fact finder, if you will. That's what you're doing. You're acting as the fact finder, and you're also, once you find the facts, then you apply the facts to the law to make your determination. So we are absolutely making decisions that affect property rights at an individual level. You're applying a predetermined law, which is, it's already been made. You're applying that law to the facts as you find them, and that's when we talked about, you assess the credibility of the witnesses and you determine which facts you want to believe and which facts you don't want to believe, how much weight you want to give to the different facts, and then you apply the law. So when you're making law, you're in your legislative capacity, and that's when we're doing comp plan amendments or we're doing LDC amendments. When we bring those to you, when you make those decisions, those are legislative decisions. Those are not quasi-judicial. And if you wanted to, you could consider other sources outside of this hearing when you're making those decisions. For example, if you have contractor friends and you're about to make a decision to change, what did we do recently? The metal. Couldn't show any metal on the facades. That's just one example I can think of. If you have friends in the industry, you can talk to them. When you're making law, you can talk to them and say, well, what do y'all think about this? As compared to when you're doing quasi-judicial, you can't have those outside resources. When you're making your quasi-judicial decision, you have to be fair and impartial. You can't bring any of your prejudices or biases or your real world things into the hearing room. When we make quasi-judicial decisions, there's got to be a notice, there's got to be a hearing, and a decision on the record. I'm talking to you about the rules of engagement. It's kind of, it goes back to the Constitution and the due process, that no person shall be deprived of life, liberty, or property without due process of law. And that's where I told you that when we do not provide due process, that's when we are most vulnerable to challenge. And that's the idea that, you don't receive information outside of the hearing, and you don't do independent research, you don't do any of the things you're not supposed to do. You don't make final decisions. So here's some things that I thought about. You don't make up your mind before we get here. Even though you've reviewed your packets, keep an open mind until you hear the evidence and testimony. Don't talk outside of the hearing about, you get your packet, you see something, and you just absolutely think it's the best subdivision you've ever seen. You still, even though you have that opinion, you don't want to talk to anybody about it outside of the hearing. You don't want to talk to one side or the other. That's, an area that we talk about a lot. Sometimes representatives of applicants will want to talk to you. We have a new lobbying ordinance in the county. It doesn't go into effect, I think, until August 1st. But people do some lobbying. I mean, it just happens. But thankfully, I don't think this board gets lobbied much, or I don't think this board, you get contacted by people. That's not so true with the BOCC. They do get approached a lot. One thing that might happen to you all is when you're doing your site visits. This may come into play if you're doing a site visit and somebody sees you out there. The neighbor or the applicant themselves. If you're out there doing a site visit, it really is just a site visit. You're just kind of getting the lay of the land. If anybody approaches you, you just want to tell them that if they have anything to say, come to the hearing. Tell you when you get to the hearing. I actually had someone ask me about a petition, and so I put this on here. You don't want to sign petitions. Kill the tennis courts, add the pickleball courts. You don't want to get involved in any of that because it may be something that you're going to make a decision on. Don't be a witness or an advocate or an investigator. You're the judge. You only want to discuss it here at our meetings after they've been noticed and everyone's been provided an opportunity to be here. Again, fair and unbiased. I'm probably repeating myself here. Oh, the last one is actually a pretty good one. And I don't know that I see it at this board as others. Once the majority makes a decision, even if you didn't go along with the majority, that's the decision. So you don't want to be out there critiquing your colleagues or saying you would have done, you wish something would have been done different or whatever. I really wouldn't want y'all to be made witnesses. When you get out, even though you've already made your decision, I don't want somebody to challenge it and subpoena you for a deposition. And, so if the board has made a decision, you just want to kind of put your head down and say, okay, that's the decision of the board. This is, for the chair, you want to use the script. Sometimes when we go off on our own, we don't get things just right. A big one on that is the rebuttal thing that we already talked about today. It's the chair's job to maintain order. Y'all want to, be civil. You want to, keep the topics to, what's going on. The freewheeling back and forth, that gets very difficult sometimes. Not as much here as other boards, but it definitely gets very difficult when there's a lot of back and forth. And you guys, really, you're good at staying on task. Except for the one time I think somebody wanted to ask a question. It was after time, and they got upset that they didn't get to ask their question. This ex parte communications, this is a huge topic right now. It seems like every day I hear about ex parte. So just so we know, in Citrus County, we have not adopted, there is a statute that allows for ex parte communications to be deemed non-prejudicial. There's a statute. In Citrus County, we have not adopted that statute. So failing that, we fall under the case law, which is the Jennings case, which says that any ex parte communications are presumed to be prejudicial to the administration of the application, if you will. And so what that says is if it's determined after the fact that there were some ex parte communications and someone wants to challenge that decision, most likely the court could overturn the decision and say that there was prejudice in the proceeding and therefore it has to be overturned. So I am very focused on protecting your decisions and protecting the decisions of the BOCC. And that's why I have consistently told the board, and I'll tell this board, don't have them. Just don't have them. If someone approaches you about something that you reasonably can foresee coming before you, just respectfully say, Mr. and Ms. So-and-so, I hear that you're very interested in this topic. I appreciate that you're engaged in, local government, but I can't talk to you about that right now. Please give your comments to staff. Staff will make them part of the record, or please come to the hearing and tell me what you want to tell me at the hearing. I know it's hard sometimes when it happens, but that's just the way we have to do it. I believe that the Board of County Commissioners will be looking at this topic because it has become such a big topic, and these rules may be changing. The way they would change is that the board could adopt the statutory language and the board could then allow for ex parte communication. The trade-off of that is if you have any ex parte communication, depending on how the BOCC handles it, you may have to create a report or fill out a form, basically disclosing the substance of your communication, who was there, what you talked about, whether it did or did not influence your decision. And then that form or that report would then become part of the record and anyone would have access to it. That is one way that some of the counties have handled enacted the statute. I don't know how the board is going to go. The Board of County Commissioners has talked about it before. Commissioner Davis brought it up, and there didn't seem to be an appetite at that time to change it. But I believe it's probably going to be looked at again. So this might change as far as ex parte is communication. Ex parte communication is concerned. But just know that just because you're allowed to, you still don't have to. So even if they change it. But the caveat with that is if you let one side talk to you, you can't really shut off the other side. So you kind of have to take a position of I'm not gonna let anybody talk to me about it, or I'm not gonna consider anything. Or if you're going to consider it, you gotta consider both sides, because I think then the whole unfairness and the due process kind of be undermined if you say, well, I'm only gonna talk to the neighbors. I'm not gonna talk to the applicants, I'm only gonna talk to the neighbors. That becomes problematic, so.
I think your analogy with the divorce judge was really good. That helped us understand it a little bit more, that you can't talk to both sides or either side. You made that to us, and it was
Here?
really helpful.
I did it here?
No, to the planners. I don't know if you did to these guys or not, but.
Oh, the divorce?
We're not getting a divorce, so.
No, I think it was, would you want the judge talking to your soon-to-be ex-spouse when you're not there?
It's
I mean,
involved in land use, but that makes it really clear. Yeah, no, don't talk to them.
you're getting a divorce, you don't want your soon-to-be ex talking to the judge about, well, I think the kid should stay with me, or, it just seems to me so apparent when you talk about it that way. It's sometimes hard with land use because it's not personal to us, not to all of us, but I thought, thank you, I forgot about the divorce issue. Okay, what's next? So this it may be subject to change, but for now, have no ex parte communications. I've got just some, I kind of did this, thanks for your interest. I can't really talk to you about this, is kind of how you want to say it to them. Even if you're out on a site visit and the owner comes out, you want to have some language, something like this that you can say back to them. Appreciate you coming out, because they're going to want to show you. If they see you out there looking at their property, oh, come on, let me show you here what we're doing in the back here. You really don't want to do that. Sir, I'm just out here to get the lay of the land, to kind of get an idea of your neighborhood. We'll talk more at the hearing. You can use staff as a resource if someone sends you an email, or somebody tries to contact you or sends you a text message, any of those types of things, just forward them to staff, because staff will make sure that they get in the record, or me. And remember, you can talk to me anytime about anything. I'm pretty much the only one that you can talk to about pending applications, and I'm happy to help. And if I don't know the answer, I'll figure it out and get you the answer. We talked about legislative. That's when you're making law, as compared to quasi-judicial when you're applying the law. Those are two very distinct. Did everybody get the distinction there? Everybody know the difference there? Okay. I'm seeing shaking heads. Anyway, I don't know. I'm kind of done. Do y'all have questions for me? Like, I could go through all this. I obviously wrote a lot.
I got one question about the
Oh, I had to show you the pretty picture.
citizen-initiated comprehensive plan text amendments. We didn't used to allow that.
Citizen initiate, you mean applicant initiate?
Yeah, applicant-initiated comprehensive plan text amendments. I mean, is that something that should occur?
I mean, it does.
I mean, just to pay a fee and submit it, or should they get the approval of the BOCC before they do that?
I can't really, that's not really within my purview to say whether we should or shouldn't. That's kind of a policy decision. I mean, it eventually gets to this board, and it eventually gets to the BOCC.
But maybe they don't want to just, I don't know. I mean, if it's in the comp plan, it should really come from this board or from the BOCC, not an applicant who stands to financially benefit from it.
That's a policy decision.
I want to know if that's AI generated or if that's a real picture.
I don't know. I thought it was cute.
That's not cute.
Well, but I mean, it's kind of the eye is in the beholder. Beauty is in the eye of the beholder. I did want to talk about deliberations. I think sometimes some people may be shy about saying what they think. I think deliberations are good, and sometimes they're very persuasive. I think some of you may have your idea on something, but one of your colleagues may say something that might change your mind. So don't be shy about deliberating. It lets the public know what you're thinking and where you stand on things, and it also lets the applicants and staff and me. So don't be afraid to deliberate. this is all very specific. You can read this stuff. No more questions for me?
Yeah, I got one.
Oh, okay. I didn't bring your list.
You didn't,
No, do you have it?
so why'd I prepare it?
I read it.
No, I didn't bring it, actually.
Oh. You don't
devel-
remember what's on there?
I sort of do, sort of, kind of.
I think I covered most of it.
No, I think you did. Question on development agreements. Is there a county or other government level, either regulation or policy or guideline on what size of development really needs to be supported by a detailed development agreement versus those that don't?
No. I mean, size. It's not based on size, and there is nothing that says there is nothing in the like the LDC that says you're required to do a development agreement if these such and such criteria. There's nothing like that. Just state law provides for them. State law allows them. If an applicant wishes to enter into a development agreement, the first step is to go before the Board of County Commissioners and to ask the board if they would entertain entering into a development agreement. And if the board says yes, then staff works with them to try to hammer it out or iron it out, however you want to look at it.
Before they come see us.
Before they come see you and before they go to the BOCC.
So we had a meeting that was coming a little bit off the rails some time ago where there were provisions of a development agreement that were being negotiated on the fly. And we.
I've never seen that happen.
No, never. But we let our feelings be known that we couldn't keep track of everything that was going on in real-time baseball. And they suggested that they would like a continuance to come back and work on it. Is there and it was complicated, I get it. Do you have the ability in your staff discussions with a developer to say, folks, this just isn't fully baked. It's just not ready for prime time. You need to go home and get this thing done.
So I think what you run into, and there are many departments and divisions within the county that give input into a development agreement, and the planning staff kind of corrals all the different different departments and divisions. So I think sometimes once something is on the notice track, we've noticed it, it's set for hearing, that train's going to keep going, chugging along, up until the quasi-judicial deadline, which is 14 business days or 14 business days, 14 business days before the actual hearing. So unfortunately, as that train's moving, things get added and subtracted along the way. It's not often pretty, but I don't know of a way to make it so that it doesn't happen other than if it gets here and you don't like, it's not, you can't make a decision because there's not the correct details, then it's a denial.
Well, there was actually a representation. Well, we were talking to staff yesterday. I seem to recall that conversation. Well,
I'm sure that they talked to staff up until the very last minute.
but if this is something else I just want to touch on. If there's a deadline and they are in fact still doing whatever they're doing, attempting to get concessions or making their own concessions, wait a minute, stop. 14 days ago, we put pencils down.
Except you're only a recommending body. So I think what applicants, right or wrong, some are like, well, that's just the PDC. And so.
I've heard that before.
Yeah, so what they're eventually trying to do is get a product that staff is going to support at the BOCC level. So they may still try to work with staff and talk to staff until the drop dead time, which is at the BOCC. I'm not saying it's good. But I'm just saying that's what happens.
Right, and when there's changes like that are verbal, it's usually something where, oh shoot, I put the wrong date or something in a condition. Those I absolutely will bring to you and say, yeah, I know it says this, but it's wrong. And they reminded me yesterday I was wrong. The quasi-judicial ordinance is so tight that neither staff or the applicant can make changes at that point. We're done. What you got is what you got. And we're really, really hesitant, well, not hesitant, we won't bring it forward. But we also will not, and if they want to change it, that's when we pull it off your agenda. You can't hear it if they want to change something that drastic. The things I bring before you that are verbal are usually something like, oh, shoot, that reference is wrong, it should have been this, or a typo or something.
Or I can also, and Eric wants to talk. I can also envision a situation where they hammer it out with staff as best they can, but they're still not happy with what staff has given them or agreed to, and they still want more. So when they come before you, maybe staff wouldn't agree to whatever, 60% ISR site-wide. Staff won't, but maybe they want to bring that to you. So that's where they're still trying to negotiate.
There's a new statute where applications have to receive a yes/no answer from the Board of Commissioners within 180 days. So applications are going to be moving faster, not slower, moving forward in the future.
Okay.
So once the application is complete, they're obligated an answer by the Board of Commissioners in 180 days.
Gotcha.
Which sounds like a long time until you start planning out these public hearings, which usually takes a month or two in advance. So they're going to be moving quick, moving forward.
So when that happens, can we negotiate? There were certain, I can think of one in particular. I'll focus that in my mind's eye, whatever that was, where they were talking about changes being made and the discussion was going back and forth. And there was dialogue with us, as the PDC. And I felt we're getting pretty close to a kind of a back and forth negotiation on some points. And certainly, I've seen the BOCC do that, and that may well be their prerogative. I don't know. I don't know what either allows them or restricts them. So the question is, when you get into that kind of back and forth dialogue with a developer, is it open? Or are we just sitting here going, you've presented this, decision being made, or you see something that's a hole, you see something that can be tightened up?
Yeah, well, you can't design it for them. You can't tell them, it should be done this way or it would be better that way. I mean, you still have, the law. But if you think you can get 3 of your colleagues to go along with you on some point.
Well, that's negotiation amongst us. I'm talking about dialogue back to
But what good does it do for you to hammer something out with the applicant
Because it
if
could
everybody
become-
else is up there going, there's no way in heck we're going to approve this?
Well, we suggest conditions, or we clarify conditions, and we go back to staff, and, there's a condition. Now, condition, staff works it out with the developer.
Yeah, I mean, I can see where it can work.
Mm-hmm.
Because ultimately, it's whether you're going to approve it or not. If you can't get it to look like something you're willing to support, then it's denial. So, I can see y'all do, as long as it's something that's relevant to what you're supposed to be doing, not, aesthetics.
Yeah, I get it.
Well, no, aesthetics, that's one I see come up, it doesn't look right, Another thing is, when you're doing these big subdivisions, the pictures of the houses and what the houses are gonna look like, it means nothing. Because we have no aesthetic standards. So if you're gonna approve something because you like the way the houses look, that's not something you should be considering.
So
Now, the
recently-
product
Or how much
type-
they cost.
Yeah, how much it costs. The product type, now
Right.
that is something you do control, because in the PUDs, you get to choose, duplex, triplex, quadplex, cluster, golf cottage, that type of thing. That is something you can consider, but what it looks like, how many stories, well, I shouldn't say stories, because that sometimes is controlled too. But basically, the way it looks, it doesn't matter.
I would think the new legislation could almost backfire, though, on the applicant, because if they're trying to shove something through and there's not adequate evidence to support all the tests and everything, I'm just gonna say denied or recommend denied, and BOCC would do as well, I would think. So they're gonna have the opportunity to continue it, I would assume, and then try to bring it back, but.
Yeah, I agree with you, and that would be my advice is, my advice is always, if you don't believe it meets the requirements of the code, you're obligated to deny it. So if you can't get there in your head that it meets it, then it's a
Right.
denial. And so, yeah, I see that too.
Yeah.
But remember, the legislature did this. I'm sure there
Yeah.
was a couple lobbyists that were involved
Right.
in that. And in practice, I definitely see what you're saying. So
Yeah.
we'll see.
I said that to say that you
The
prob-
timelines are gonna be
Well,
like.
you will probably get a little bit more negotiation from the podium or attempted negotiation from the podium because the timelines are faster and they may not have had an opportunity to come with consensus with staff. So it may be a little messier when it comes before you
Right.
because the timelines are so tight on their end.
Well, maybe I missed it because I was looking at my list. If someone asks for a continuance, a party asks for a continuance, is there a minimum time between their request and they get back on the agenda?
No, it's whenever whenever the schedule allows, because it has to be properly noticed, the abutters have to know about it, so it's usually never gonna be your very next meeting, because you've already have those scheduled. The one thing I did wanna say is, I don't know that everybody realizes this, when they ask for a continuance, you can say no. That actually happened, to me the other night at a different jurisdiction where the applicant wanted to continue and that board said no. So at that time, the applicant was like, wait, I don't have my experts here. I don't have everything here.
You have
I feel
in the
like we
past.
have.
Have we?
Yeah,
No
we
matter
have.
what you said, like, it's,
It's still,
we've done that.
still, and I appreciate that when you do it. I like when the applicant does a continuous because we're not paying for those notices. When we decide to, so we don't propose a continuance. Staff's not gonna do that for you. We will tell you, we think it's got a lot of issues, nicely, but we're not gonna say, and it needs to be continued. You're not gonna hear that from us. We
No.
won't bring it forward to you if it's not complete.
So what happened with that case is, I guess we went forward, the applicant seemed to think that it wasn't going in their way, and they withdrew their application so that they didn't have to get a denial. Any other questions?
Quick question on
One more.
these interchange development areas.
Promise.
Yeah. Floor surface. If I don't know, I'm gonna ask the question, I'm sorry. The floor surface areas,
FAR, floor area ratio?
Yeah, floor area ratio, sorry. We've seen a few of these in these interchange development areas where somebody wanted to build multi-story building. So I'm not asking to go through all that today, but I need you to point me in the right direction, because I've not wrapped my head around that.
So floor area ratio is intensity of the lot. So if you've got 3 stories and they're 1,000 square foot each, you've got 3,000 square feet divided by the total size of the lot. So if the lot is 10,000, and it'll be 3,000 divided by 10,000, that's your floor area ratio. So it's meant to, if you have a tiny, tiny lot and 20 stories, that's really intense. So that's why the floor area ratio is there. So you don't put a really, really intense lot, a high building basically with a lot of floors on a tiny lot. Floor area ratio is in the comp plan. There is no deviations from it. We've had people try, and we tell them we won't even bring it forward to you because they just cannot. It's in the comp plan hard and fast. So the discussions in some of the interchange managements by the builders are, well, you really need to be higher. And it's up to whatever the board chooses. If the board says no, the floor area ratio, or you can only have 3 stories, that's it. You're done. That's in the comp plan, and that's all you get. So you gotta dial back a little bit. The
Point me in the
intensity.
right direction. Where is it in the comp plan?
The floor area ratio is in each individual, it's in the land use, future land use chapter 10
Mhm.
in the comp plan.
Okay.
But
So
there's also
sim-
a definition of land development, I'm sorry.
No, it's similar to, I've showed you the charts and the LDC.
Right.
It's similar to that. Each land use category in the comp plan has the designated FAR.
And there's a diagram and a definition of what floor area ratio is in the land development code, that's good too. It's
Gotcha.
a nice,
Thanks.
pretty diagram.
didn't we just talk about some floor area ratio and something being changed with one of the regular applicants, attorney?
Yes, he
Yeah.
he wanted to,
Correct.
and he ended up continuing, because you cannot get a deviation from it.
Right.
They're actually doing a land use change to try to, because of the floor area ratio.
Right.
Yeah.
Yeah, so the floor area ratio in that particular instance, it kind of, if we're talking about it, we are, obviously, that we're a waterfront community. A lot of things have to be on stilts, and it's not gonna be a living space down below. It's just a parking space.
Right.
So counting that towards the floor area ratio,
Right, and that passed, it was
Yeah.
worded very carefully, because people have tried to shove things down there too, but yeah.
Right.
Yeah.
okay. I
Yeah,
thought
once they
so.
get there, then they close it in and it becomes a
Well,
basement.
that happens everywhere anyway.
But that's not residential. Floor aeration doesn't apply to houses. It's only for commercial.
Yeah, commercial.
Why was it, okay, so in that particular instance, it was because there were multiples, right? There was a bunch of them?
It was commercial.
Commercial.
It's a
But they were gonna be used residentially. It was a commercial property residentially used.
No, because there was multiple on there, so it was
Multiple
multifamily commercial. Yeah, not residential.
Multifamily is commercial. It's not
Less than,
residential.
less than 4 units.
No.
No.
No, it's 2.
The county considers 2?
Yeah.
Anything more than 2 is considered commercial?
It's multifamily, which is commercial.
Multifamily.
Yeah.
Okay.
Which is different from the plan that you looked at, because remember, the plan you were looking at had within the plan, had its own definition of multifamily and single-family.
Right. Yeah, because the
Just to
Realtor
confuse
definition
you
of
different, yeah.
multifamily is,
Because it was an old DRI.
yeah.
I'm good.
Oh, you're not gonna ask your question now?
Okay, yeah, I will. And everybody's anxious to leave, so and as quickly as you can summarize, conditions applied or negotiated or requested to development agreements. As we saw recently, I think there was 20 that were attached to a project that was recently approved. And there were additional conditions placed on that project by the BOCC. Is that standard practice, and what is the ability of this board to Bob's point, to negotiate or to suggest, maybe you might consider this, not because it would change my vote, but I think it might be more attractive to the board in total if this item you would agree to do.
I hate to make a blanket statement, yes or no. I think it depends on the circumstances. I mean, when you're looking at something as big as that project, I think you can talk to them about things. But if you're looking at a small little thing, I hate to make a blanket statement. I think we'd have to see as we go through it, see if your board has an appetite for it. I mean, if you've got 6 people glaring at you like, what the heck are you doing, then probably not gonna get support in the end.
Yeah.
So.
Well, yeah, but during the course of the conversation and deliberations and questioning, you can get a sense of whether there's support for something like that or not. I mean, I get a sense of that. Okay. Because I don't mind bringing it up if it needs to be brought up.
Well, Denise, we thank you for putting up with
Thank
us,
Oh,
adding extra
I try.
knowledge to our
It's-
brains, but we
it's
appreciate
hard.
your time.
You're welcome. It's hard when you have applications. It's easier, like in this setting, to try to hammer out some things.
Yeah, I don't get to talk to you at all, so it's, it's nice too. I mean, when you guys are negotiating and doing your deliberations, I can't jump in. I try, but I can't really jump in and say, but, you're welcome to ask. It's okay, How about this condition? I'm really good at writing them on the fly. I don't mind, but you gotta ask.
But you can ask the conditions from staff, both staff and for the applicant, and obviously in separate.
Well, I mean, they don't have to agree to them.
No, they don't.
I mean, I think that if in some instances, depending on what it is, the applicant probably might not like the condition, but if it's gonna get your approval, okay, fine, I'll do that.
And
Well,
then
that's the
it'll talk to
definition of a
BCC.
good deal.
Yeah.
Not everybody's happy. Okay.
All right.
Mr. Landon, did you have anything you wanted to add? No, you've been very quiet. If we move on for a second, your next 2 meetings in August, you got 3 applications on each one, so we're gonna be busy. The first meeting in September, that's September 4th, we have a very high interest, controversial perhaps, application, so I know that's the Labor Day world, so if you can be here, please do, we'd appreciate that. And they just keep coming, we're not slowing down.
Well, thank you.
Thank you.
Motion to adjourn.
Motion.